Fieldy and Lee Reynolds.
Good morning, my lords. Good morning. I appear in this matter together with Mr. Luke Pearce on behalf of the appellants, the insurers, and my learned friends Mr. Stephen Berry QC and Mr. Neil Hart appear on behalf of the respondents Assurans. The present appeal is concerned with two questions of law as to the proper approach to calculating whether a vessel is a CTL. The first issue is whether costs incurred by the respondents, the owners, prior to the date of the notice of abandonment can be ranked towards a CTL calculation. The second issue is whether scopic costs payable to salvors of the vessel can be ranked towards the CTL calculation. The courts below answered both of those questions in the affirmative, and for the reasons that we have summarised in our written case, we say that they were wrong so to decide and that this court should overturn those decisions.
You can take it, incidentally, that we have read carefully the cases on each side. What we haven't done is looked at all the authorities that you refer to.
Yes, my lord, that's very helpful, thank you. I'll proceed on that basis.
Well, on the subject of what we have looked at,
yes.
I think I'm right in saying that there are no P&I terms in the bundle. I presume that this ship was entered, presumably with the Swedish club, for standard P&I risks.
My lord, that's right. There are no P&I terms in the bundle. The ship was entered with a P&I club for P&I cover. It was not with the Swedish club. It was with the American club.
Right.
But I don't recall whether those terms were in the evidence before the first instance court, but they're certainly not in the bundles that we have here.
I mean, in the ordinary way, pollution liabilities of the sort avoided by scopic costs would be covered under the P&I clauses.
Yes.
I presume that was the case here.
My lord, that was the case here, and the scopic liabilities were in fact paid by the American P&I club. There was no doubt about that.
That's common ground, is it?
That is, I believe so, my lord, but that was common ground at trial.
I think so, my lord, if I just have a locus penitentiae to check.
Of course.
So, my lords, the third issue, which you would have seen covered in the written cases, is what the consequences are if we are right on either the first or the second issue. In my oral submissions, I propose to spend most of my time on the first issue. The second issue, though it's important, is of much narrower scope, and I can deal with it quite briefly. The third issue we have addressed at some length in our written case, section F, and if time permits, I will say a little bit about that orally, but I'm intending primarily to rely upon what we have said in writing in relation to that, certainly in relation to all of the points of detail. And my lords, so far as I'm concerned, I don't think there is any real dispute between the parties in relation to the various figures and permutations when one gets to issue 3. My learned friend will no doubt correct me if I'm wrong on that, but that is my present apprehension.
Is the large margin issue within the scope of the matters for which leave was given?
My lord, no, I don't believe it was.
If not, it would be an application for special leave.
Yes, by that may well be right. By the respondents. My lord, in terms of allocation of time, the parties have agreed, subject of course to any different views from the court, that we should divide time equally, and what we have agreed is that I should have from 10:30 now until 1 o'clock, and then from 2 till 2:30 this afternoon, that my learned friend should have from 2:30 until close today, which I think is 4.
Yes, we have your timetable.
You have that, my lord. I'm obliged. My lord, the only other question I wanted to just ask, sort of housekeeping is whether you intended to have a 5-minute break mid-morning for the transcribers or whether we will just press straight through.
We would intend just to carry on. Good. Well, but I've been persuaded that we should have a short break. So we can aim to break for 5 minutes at about 11:30.
Thank you, my Lord. My Lord, turning then to issue 1, and by way of introduction to it, I'm going to begin with the position as it pertains under the Marine Insurance Act and at common law. Our case is, once that position is ascertained, it will necessarily inform the position under the policy wording. And as I will explain in due course, the policy wording could only produce a different result to the result under the Marine Insurance Act and the common law if the policy wording were clearly inconsistent and overriding. And for the reasons that I will explain, it is not. But the starting point, certainly for my purposes, is to consider the position under the Marine Insurance Act and at common law. My Lords, most of the material terms of the Marine Insurance Act are have been set out in our written case at paragraph 10 on page 57 and 58 of the core bundle. And I'm not going to read through or repeat them now. My Lords, can I just draw your attention to one other provision of the Marine Insurance Act that it is important to have in mind from the outset, and that is section 91, subsection 2. And we have that in the authorities bundle 2, tab 70. And I hope your lordships will have an insert right at the end of that tab, page 1464D. Once 1464D, my lords, section 91(2).
That was a loose document sent in by letter on the 8th of, I think the 8th of April. This should be
Yes, I've got it.
I received it, but I've left it in my room. I'm sorry.
No, not at all, Mark. The section is heading savings, and subsection 2 provides that the rules of the common law, including the law merchant, save insofar as they are inconsistent with the express provisions of this Act, shall continue to apply to contracts of insurance. My Lord, that is important for reasons which I'll explain shortly. Now, in terms of the proper approach to the interpretation of the codifying statute, a codifying statute such as the Marine Insurance Act, the cases which we refer to in our written case provide clear guidance, and I'm sure they will be very familiar to your lordships. Samuel and Dumas, that we refer to in footnote 9 of our written case, provides that if the code is clear, references to the previous state of the law prior to the code are irrelevant. You just apply the statute if it is clear and unambiguous. But what Viscount Finlay said is that one may look to the previous state of the law prior to the code if the code leaves anything in doubt. And to similar effect is Lord Herschel's guidance in the Vagliano brothers case, to which we refer in our footnote 9. On this, my lords, and finally, in the Black Clawson case, which we refer to in footnote 8, Lord Diplock made clear that when the court is seeking to inform itself as to what the existing law was, if and insofar as that may be appropriate, it may have recourse not only to decided cases, case law, but also to textbooks or any other writings of recognised authorities which set out summaries of the existing law as understood. As I said, it is important in this context to bear in mind Section 91(2) of the Marine Insurance Act. That provision entails that at least the following common law rules continue to be applicable in a case such as the present. First, that the vessel must in fact be a CTL at the time that notice of abandonment is tendered. Second, that the vessel must in fact be a CTL at the time the proceedings are commenced. And third, that the prudent uninsured owner test, which is developed at common law, is to be applied when determining whether the vessel is a CTL at any particular time. So those are all rules of the common law, and there is nothing in the Act that is inconsistent with the continued application of them. Therefore, they all continue to apply and have to be considered. My lords, we set out the material terms of the insurance policies in paragraph 13 of our written case, and the court will, of course, appreciate that there is a major issue between the parties as to whether the policy terms can produce a radically different result to that which would follow from the terms of the Marine Insurance Act and the common law. And we say plainly not. What I'm going to do is follow the same structure as in our written case. So I'm going to deal with that sub-issue after I have dealt with the position as it pertains under the Marine Insurance Act and at common law. I would still, by way of introduction in relation to the first issue, can we just pick up paragraph 15 of our written case? My lords, there is no doubt that in this case, in order to bring a CTL claim against my clients, the respondents had to serve a valid NOA. That was a condition precedent to a CTL claim in this case. And in order for the NOA to be valid, it is well established that the vessel has to be a CTL as at the date of the NOA and also as at the date of the commencement of the action, if that is a later date. And my lords, that was accepted by the Court of Appeal, and that's paragraph 82 of the Court of Appeal judgment, core bundle 7A, 2, page 165, and that is not, that point is not disputed on this appeal. My lords, we say, and I will develop this, but we say that the vessel's status, its condition, its status at an earlier point in time is simply not relevant in this case. Where an NOA is a condition precedent to a CTL claim, it is not necessarily sufficient that the vessel was a CTL, in fact, at the date of the casualty. That's not sufficient. Nor, conversely, is it fatal to a CTL claim in these circumstances that the vessel was not a CTL originally at the date of the casualty. And therefore, it is generally pointless to ask the historical question. What matters is whether the vessel is a CTL at the date of the NOA, and if later, also at the date of the commencement of the action. So for example, the vessel may not have been a CTL at the time of the casualty, but could be a CTL by the later date at which NOA was given. Imagine this situation. If the vessel was originally faced with a situation that deteriorated, over the course of days or weeks. So say, for example, she drifted further onto the rocks or became more firmly stuck aground in the days and weeks after the original casualty. First of all, the damage that she sustains may increase. Secondly, quite irrespective of any further damage occurring, the costs of rescuing the vessel from the situation of danger may increase. It may become much more difficult and much more costly to get the vessel off the rocks if she has become more firmly stuck aground. And additionally, of course, even if the vessel's physical situation, the circumstances in which she is placed, continues to be exactly the same, there is no deterioration in the physical situation, the costs of salving and repairing the vessel may vary over time, including because of market forces.
If the vessel becomes, to take your example, more firmly stuck aground, originally, law will treat all of that as a consequence of the existing casualty, the original casualty, will it not? It doesn't say there are two casualties here. It simply says that as events have worked out, the additional cost of getting the vessel off the rocks after it has become more firmly stuck on them is a consequence of the original casualty.
In terms of causation, my lord, yes, I would agree with that. But it doesn't alter the fact that the original casualty started on day one, and the consequences, the causes of that original grounding are still continuing. But it's still, if you ask what is the date of the casualty, it is the date that the vessel, in this example, it's the date that the vessel first went aground on the rocks.
But now the examples that you cited are all examples of what perhaps is the classic way that the problem arises. They arise from changes over a period of time in the amount of knowledge that you have about the consequences of the casualty. Any CTL calculation is going to, most CTL calculations are going to involve a reasonable prediction of the future, at least for some purposes. And the amount of information that may inform that prediction may change over time, so that what it is reasonable to predict may be different at point of time A than it was at point of time B. And that is the explanation, is it not, of the proposition that something may be a CTL at one of those points and not at the other.
My lord, I would say that is a related, but actually a logically distinct point, a point about knowledge. I completely accept what your lordship says, that knowledge may turn over time and therefore may change over time, and therefore the predicted costs may vary at different points in time as the knowledge picture develops. But there is a separate point in my submission, which is the actual situation may change over time as well. And in the example, in all of the examples I've given, they really are changes in the actual situation, because you have the vessel physically going more firmly aground, and you have actual costs of repairs varying, potentially because of market forces. Now, when I say that, and take this concrete example, if you ask at the time of the casualty, what are the costs of repairs for a particular type of damage, you may get a quotation from a shipyard that at that time will do the work very cheaply. It's an actual quotation. Now, if you ask the question a month or 2 months or 3 months or 5 months later, the market situation may have changed altogether, and you simply cannot get the repairs done at that price. So it's not a question just of knowledge development, it's a question of the actual circumstances changing as well.
Exercise that you're performing is to determine what are the losses arising from the casualty. Supervening events may make those losses greater or less than you previously thought.
Yes.
But the exercise still involves asking what losses, as events have turned out, have flown from this casualty. Isn't that right?
My Lord, yes, I see that, but that involves a comparison between the costs that you may estimate on day one, when the casualty first occurs, taking into account what you see may happen, and the costs that you may estimate a week, 2 weeks, or 5 months later, taking into account what has in fact happened. And in my submission, those are quite different exercises. I take your Lordship's point that at day one, you can try to make a prediction based upon foreseeable events.
They're the same exercise, aren't they? But informed by a greater degree of knowledge, because you know what's happened subsequently and you know how repair costs have developed and so on. But the exercise you're performing conceptually is exactly the same.
Yes, but you're taking into account a different fact and knowledge position at the different points in time.
That's the difference.
Indeed. The converse of the point that we've been discussing, my lords, is that a vessel could be a CTL at the time of the casualty on day one, but not subsequently, due to some change in circumstances resulting in an improvement in the vessel's overall position and situation. And that must follow. Again, I don't disagree with Lord Sumption's point that on day one you are trying to look forward and predict the future. But if on you may take the view reasonably on day one that the vessel is a CTL because it's going to be impossible to extract the vessel safely from its grounding position. A week or 2 weeks or 3 weeks later, you may take a very different view on that. And that is not necessarily just, it's the same point, it's not just because you can obtain more information about the viability of salvage. It's because 2 weeks, 3 weeks, 4 weeks, 5 weeks later, the vessel's actual position may have changed. Its physical position may have changed in a way that you may or may not have been able to foresee. So it's the converse of the point that I've been making, my lord. So we say that a rule whereby you ask whether the vessel is a CTL looking forward from the date of the NOA is clear and workable. There is a clear and certain point in time at which the question CTL or no is to be asked and answered. And importantly, very importantly, the focus is always on the state, condition, and circumstances of the vessel, circumstances facing the vessel at a particular point in time. The question being, at that time, given the circumstances then prevailing, is the vessel a CTL? My lords, as we note in paragraph 18 of our written case, until relatively recently, and critically we would say, at the time that the Marine Insurance Act was being enacted, it appears to have been regarded as trite law that expenses incurred prior to a notice of abandonment do not count, cannot count, towards a CTL calculation.
Is there any authority that supports that apart from Judge Carver's observations in Bogota?
My Lord, there is no authority, there is no English reported case that either side has been able to find that deals with the point either way. There's no case that says pre-NOA costs cannot count, but there's no case that says that they can count. My learned friend suggests otherwise, but I'll show why that is not right. But my lords, we do, as you will have seen from the written case, and I'll develop the submissions briefly, but we do attach very considerable weight to Mr. Carver's presentation, not just because it was from Mr. Carver, but because of the audience to which it was delivered, and the lack of any hint of any disagreement with what he said, and the fact that his presentation is referred to with approval by, amongst others, the editors of Arnold and Chalmers. My Lord, there are US authorities, and of course Carver's presentation was addressing various systems of law, not just English law. There are US authorities, which I will show you, Humphreys and Dickey, which are absolutely in point. They are both cases where the insured incurred repair costs prior to the tender of an NOA and said that it wanted to rank those costs towards a CTL calculation. And if it was allowed to, the vessel was a CTL. And the US courts said in very clear terms, you can't do that. Pre-NOA costs are irrelevant. They can't be taken into account. And I'll show you those cases, but they are very clear. There are very clear US authorities on the point.
Are you, on the chapter of your submissions you've just given us, are you going to be coming on to discuss the judgment of Mr. Justice Roche in Rura and Forgas?
I will deal with that in due course if necessary.
Because, I mean, he takes a view that, as he puts it, probability and not the event is the test. And the reason, he says, why restoration precludes recovery is not because there wasn't a constructive total loss, but because under the contract of indemnity, although you may at one time have suffered a loss, you can't recover if it's been made good to you. So, in other words, it draws attention to the language of probability in section 60.
My Lord, yes, I will come back to that. Can I think about that and come back to it? So my Lords, our submission is that Carver's presentation reflects the fact that it was well understood, clearly understood at that time that pre-NOA costs could not rank, both as a matter of English law and American law. And my Lords, consistent with that, we say the point was correctly conceded by a very experienced senior counsel, as he then was, in Hall and Hayman. Now, my Lords, prior to the 1961 edition of Arnold, so over 50 years after the Marine Insurance Act came into force, there appears to have been no authority of any nature, including any textbook, suggesting or supporting the view that pre-NOA costs could count towards a CTL calculation. And although the Carver presentation was referred to with approval in earlier editions of Arnold, what appears to have happened is that later editors forgot about it or overlooked it. And what seems to have happened is that from the early 60s, the editors of Arnold started to question whether pre-NOA costs could rank towards a CTL calculation, and started to set out the view that the better interpretation was that they could count. And we submit with respect that that was a wrong turn, and it was one which has caused or contributed to the judge and the Court of Appeal going wrong in this case. My Lords, I'm going to turn to the key stages of our argument as we set them out in the written case in a moment. But before I do that, can I make one last preliminary point? And it's really just picking up and emphasising what we say in footnote 3 of our written case, citing what Lord Ellenborough said in Bainbridge and Nielsen. Can I just remind your lordships of that? I won't read it out again. It's Core Bundle, tab 5, page 55, footnote 3, starting at the bottom of the page and continuing over onto the next page.
And that is because the insured value is higher than the actual value?
Absolutely, my lord.
In the vast majority of cases, is that right?
Absolutely, my lord, yes. In the vast majority of cases, and certainly in this case.
Yeah.
That's not necessarily it may be a windfall for the owner, but very often the agreed insurance value will reflect the terms of the loan agreement under which the ship has been mortgaged.
Yes.
So that it doesn't necessarily, if it's a windfall, it's not necessarily a windfall for the owners.
My lord, I would agree with that. It doesn't necessarily go into their pocket, or it certainly doesn't necessarily stay in their pocket if it does. I would accept that. But the point is that Lord Ellenborough was emphasising is that it is almost invariably in the assured owner's interest to claim for a CTL if he possibly can.
Well, that's true in the sense that you don't have an argument about it unless the ship is overinsured, because it makes no difference.
Because usually the insured value will be great, not always, but usually the insured value will be greater than the market value. So they're the 2 points. But for similar reasons that Lord Ellenborough gives, I would urge this court to be careful about enlarging the grounds of abandonment. And I do submit that if pre-NOA costs can rank, that does enlarge the grounds of abandonment, because it would allow the assured to recover for a supposed total loss which did not exist at the time of the NOA. And it also allows the assured to rank costs to a CTL that were incurred prior to the underwriters even having notice of the casualty and any steps being taken to deal with the casualty. So the insured can incur costs without any reference to the underwriters, and then use those costs that have been incurred to make up a CTL claim.
I'm sorry, could you just explain that point again, please?
Yes. If pre-NOA costs can rank, then
I see. I'm with you now.
The consequence is that the insured can incur costs without reference to the underwriters, without even informing the underwriters that there has been a casualty and that costs are going to be incurred.
Yeah. And
then it can use those costs to justify its CTL calculation. And my lords, while I'm not suggesting, and we have never suggested that there has been any abuse or fraud in this case, one can see the risks and dangers of abuse if an insured can incur pre-NOA costs and rank them in that way. My lords, turning to the steps in our argument, then, we start with the wording of the Marine Insurance Act. and our submissions are summarised in paragraphs 22 to 30 of the written case. So starting at page 62, tab 5 of the core bundle. My lords, I'm not going to read out the terms again. We've set them out. We have added emphasis to the points that we rely upon. And the two headline points that we make arising out of the wording are first of all that in our submission, the focus of the wording is on estimated future hypothetical expenditure that would exceed a particular value if or when it was incurred.
You've amalgamated two quite different things in that formulation, haven't you? Would, on one view, simply reflects the hypothetical nature of the calculation in the majority of cases. You are saying it not only reflects its hypothetical character, but it reflects the principle that only future costs are relevant. Now, those are two completely different reasons why you might use the word would, and only one of them will do for your argument.
My lord, I can't disagree with that. And my lord, that is focusing just on the word would exceed. The other words that we emphasise are in estimating. That this is all about estimating. It's not about taking into account actual costs that have been incurred. But my lord, my lord is right to say that there are two available interpretations of the language. I'm not going to suggest that there is only one meaning and that no other meaning can be given to the language. My lords, that is if one is just looking at in estimating and would. But you have to read this section as a whole, and the word future is important. We say that certainly tips the balance in favour of our overall submission. You can't. It wouldn't be right just to look, for example, at the first sentence of section 61 and work out what that means without taking into account the whole section. And we do say that looking at the section as a whole and construing the words as a whole, particularly taking into account the word future, that the better interpretation of the language is as I submit, that it's about estimated future hypothetical expenditure. And we say that that is reinforced by the word future. We say that both indicates and reinforces the view that only future expenses are relevant, and that consequently, and I'll come on to this, but we say consequently past expenses are excluded.
Why was it necessary to deal specifically with general average contributions?
My lord, I'll come back to that, but I think our short answer is that the references to general average contributions and salvage operations in section 62.2 is to make clear that those are to be treated as costs of repairs for the purposes of the CTL calculation, because they don't naturally, as a matter certainly of ordinary language, certainly to a non-shipping law, they don't naturally costs of salvage operations don't naturally seem to be costs of repairs. And the same with general average contributions. They're not to do with actually physically repairing an object. So we say we say that the reference there is to make clear for the avoidance of doubt that these particular items are to be taken into account when you're looking at the costs of repairs, even though they may not naturally be regarded as costs of repairs. And we make that point, my lords, in paragraph 64(2) of our written case.
Generally, a general average is simply a mode of distributing the cost among the various interests which benefit, including the cargo interests, so that it would be irrelevant to the question what were the relevant charges. It's only concerned with distribution once you've ascertained them. And so on any view, this proviso is a slightly odd thing to deal with at all.
My lord, I can agree with you on that, certainly.
Can I ask you a slightly different point? How does your submission, well, your submission seems to be premised on there being a notice of abandonment.
Yes.
But what if there isn't?
My lord, I'll come to,
You're going to
if
come
I
to-
may, I'll come to that in the next stage of the argument. I'll develop the point, but the short answer is that the Marine Insurance Act sets out the test that is to be applied for CTL, but it doesn't say anything about the time at which you apply the test. It's not time specific. And the question as to the time at which you apply the test depends upon the particular case and is guided by the common law. So
There's
that's
2
where you
points,
come.
aren't there? One, at what time do you apply the test? And 2, to what do you apply it? One doesn't carry the other.
My lord, not necessarily correct, but our submission is that the test, as per the wording of the statute, and I will look at the prudent uninsured test as well in a moment, but as per the wording of the statute, the CTL test is forward-looking, and the prudent uninsured test that informs the CTL test is forward-looking. So that's point one. The second point is, well, what time do you apply the test? We say the statute doesn't give you the answer to that. It leaves it open because there is no single rule. You apply the test at different times in different cases, and the common law tells you what time to take in any particular case. But, my lord, I'll develop that momentarily.
So are you going to be, I mean, is the answer to my point that you only confine your attention to costs incurred after the NOA in a case where an NOA is served?
Yes, in a case, yes, my lord. In a case where an NOA is, yes.
And
In a case where an NOA is a condition precedent to a CTL claim.
Yeah, and so I'm interested to know what the approach is in a case where no NOA is served.
My lord, we address that in our case, and I'll come back to that.
Well, under the hull policy, the result surely is that you have to claim as a partial loss.
Unless there is a waiver, my lord, of any right to an NOA, or there are two exceptions.
That's provided for by the Act.
Subsection 7 and 8 of section 62.
Absolutely, my lord. There are two now. In those cases, an NOA is not required even for a CTL claim on a hull policy, what Mr. Carver suggests in his presentation is that in those sort of circumstances, you would ask the CTL question at the time of the event that rendered the NOA unnecessary. So when the waiver...
There may not be such an event. Let's suppose that the insurer were to say, just to take a particularly clear case, don't worry about serving any notices, we'll just look at the situation as it develops, all right?
Yes.
So that would be a clear waiver of the NOA. So in circumstances like this, where you are incurring costs from time to time, salvage, emergency discharge, possibly provisional repairs and so on, at what stage, if there's a waiver, do you look at it? Because it might be said that the only thing you can do in those circumstances is to ask what have been the consequences of the casualty, looking at the whole history. In which case one's bound to ask, well, given that the actual existence of a CTL is a condition precedent to the right to give a notice, why should it make any difference?
I see that, Manu. Manu, can I think about that? Certainly our submission is where an NOA is required and is given, then it has to be a valid NOA to permit a CTL claim.
I.e. there has to be a CTL.
There has to be a CTL, and we say certainly in that case, you have to ask the CTL question at the date of the NOA. Now, see the point that if there is a waiver, or if the circumstances are such that an NOA is not required because it would be pointless to give it. Now, the situation covered in some of the cases is where the vessel is sold, and these are very, very old cases, so it's difficult to think that they could ever occur in the current day, given instantaneous communication. But cases where the vessel is sold in a foreign port before even the owners know about it, because the master sells the vessel. Now, there's nothing in those cases to abandon to the underwriters, so it said, well, no notice of development is necessary. And in that situation, and we'll come to Carver's presentation, but Carver would suggest that you have to ask a CTL question at the time of the event that rendered the NOA unnecessary. So that would be at the time of the sale of the vessel. So was she then a CTL?
So in the hypothetical situation, it might be weeks or months before either the owner or the insurer was aware that the vessel had been sold.
Indeed. But no, I think the point is, my lord, there is no, these are difficult questions, but there is no basis for suggesting that you ask this, because of them, you ask the CTL simply at the date of the casualty. That there is no logic to.
No, that's not the suggestion. The suggestion is that you ask the CTL question at the date of the notice or at the date of proceedings being brought. But the question that you then ask is, what have been the consequences of this casualty over the whole period since it happened? That's the argument. Well,
that's the argument made against this one. We say that you don't get any support from that from the wording of the statute, no support, and we say that you don't get any support from the common law cases either.
You don't get any support for the contrary proposition simply by saying that you ask the question as at a particular point of time, because what matters is what is the question and not when you ask it.
My lord, yes, of course I accept that, and I'll develop it, but our submission is that the wording of the statute just looked at in isolation is forward-looking, but it's also to be informed by the prudent uninsured owner test, and I will come on to that.
Your point's rather focused by section 62, subsection 1, which we're giving you a right of election between claiming a partial loss and serving a notice of abandonment, where there is a constructive total loss. And so there must be in existence a constructive total loss objectively before you elect.
Yes. I see that, Manu, but that just emphasises that the question is time, I would say, is time specific. So on any particular day, if I'm right that the test is forward looking, and on any particular day, you can ask yourself, is the vessel a CTL in fact? Applying a forward-looking test. But my submission is that in this case where an NOA is required, the vessel has to be a CTL at the date of the NOA, applying the forward-looking test. My Lords, I'm not. I don't want to spend time asking you to read or read again now the using the Lowndes and Rudolph textbook that we have referred to in our written case. It's the 12th edition, my Lords, and the Law of General Average and the York-Antwerp rules. And can I ask your Lordships to, it's not just dealing with this point about the wording of the statute, it's dealing with the question of pre-NOA costs more generally. But my Lords, can I ask you please in due course to read the entirety of that extract. It's tab 57 of the authorities bundle. The 12th edition was by Mr. Wilson, the past chairman of the Average Adjusters Association, and Mr. Julian Cook. And my Lords, can I, in due course, will you please read paragraphs 50.111, starting on page 1379, through to the end of that extract on page 1384. Now, those authors suggested in that text, for various reasons, that pre-NOA costs could not rank. One of the points that they make, and of course it's just their interpretation of the language of the statute, but their view on the language of the statute was that every single relevant phrase in these sections looks only to future expenditure, not to that already and historically concurred. And looking at the language as a whole, I would endorse and commend that view to you.
Does this deal with simply with the general average aspect of it, or does it deal with the background under the whole policy?
My Lord,
I think maybe the latter. I'm looking at page 1381.
it's the latter, my Lord. It's not limited to the general average
I see that.
aspect. And my Lords, our point is that the CTL question has to be asked at the date of the NOA, taking into account the facts existing at the time that the NOA is given, not the facts existing at any earlier point in time. And that's why the test is forward-looking, because it is looking at the factual situation at a particular point in time and looking forward from that. And, my Lords, can we just turn in the Authorities Bundle 2 to tab 45, please? My Lords, this is the most recent edition of Arnold on marine insurance. And my Lords, can you please turn to page 1292, 1292. And my Lords, can you just please read paragraph 2907 to yourself? It's just the first paragraph of that, starting on 1292, ending halfway down 1293. So, my lord, our point is the focus has to be on the state of facts existing at the time when the NOA is given.
Is there,
That makes sense. Sorry.
I'm just going to ask, is there any authority for that other than in the capture and recapture cases or the detention and release cases?
Yes, my lord, but not, as I accepted earlier, not
recent.
as an English, not an English
See, the
authority
Americans.
that really grapples with the point. I will show you briefly Hall and Heyman, just for the analysis of the judge in that case, which does focus on this.
But I mean, the capture and recapture cases are dealing with a completely different situation, aren't they, to the one we're concerned with? Because they are concerned with a situation where the ship was captured, but that then was undone, so that when you look at both together, it is clear that no loss at all has occurred.
Yes.
Whereas on facts like the present, where certain costs associated with reinstatement of the vessel have been incurred, you are looking at something which has undoubtedly caused a loss. All that's happened is that part of it has left somebody's pocket already. That's a very different situation conceptually, isn't it?
It's obviously a different factual situation. I would say that I would submit the same test and the same approach is to be applied in both situations, which is that you look at the existing state of fact, and it's fact concerning the situation of the vessel, what state the vessel is in. You look at that question at the time of the NOA in both cases. My lord, that was certainly what was done in Hall and Heyman, and of course there was a concession in that case, but I say the concession was rightly made, and I will show you the passage in Mr. Justice Bray's judgment. That's a repairs case, and it was certainly the position in the clear US authorities that I was showing, Hickey, Humphreys and Dickey.
But what you can't say, if the ship has been recaptured, you can say the loss, looking over the whole period of time and all we now know, never happened. You can't say that in a case where some money has been expended, let's say on emergency repairs at the site of the casualty, because the cost of the emergency repairs is a measure of, at any rate, part of the loss. It's the very thing that's insured.
Well, my lord, even in the recapture case, you would not say that the loss never happened. It did happen. The ship was captured and was lost at a particular point in time. The analysis is that at the time of the NOA, the ship is no longer totally lost.
Well,
or at the date of commencement of the proceeding.
That's not right, is it? Because if the ship has been captured, the question whether that constitutes a loss of the ship depends on its permanence. If it's recaptured, once it's been recaptured, you know that it wasn't permanent, it wasn't a loss of the ship at all, it was merely a temporary deprivation of possession.
With hindsight, you can see that.
Absolutely.
Yes, I accept that.
So it unmakes the loss in a sense which is not true if you partially reinstate a damaged ship.
Well, yeah, I see that, my lord. I see the conceptual difference, but in my submission, the analysis is the same in the two cases. You focus on not what has happened in the past. You focus upon the present situation, and the focus is on the condition and the circumstances of the ship at the time that the NOA is given, and if later, the date of commencement of the action. And that is the clear, and we say principled test that should be applied in all cases. And as I will show, the respondent's contention and what the Court of Appeal has applied in this case certainly involves asking the CTL question, we would say, at the date of the casualty. And that is wrong. That is not supported by any of the cases or texts.
Now, I wonder if that might be a convenient moment for us to have a short adjournment.
Yes, thank you. Thank you, my lords. I'm going to try and accelerate slightly because I've still got quite a lot to get through.
Yes, of course.
My lords, once it's appreciated that the CTL question has to be asked at a particular point in time, then we say that the meaning of the word future in the section becomes clear. And it must mean future from the date to which the inquiry relates, whatever date that is. So if you are asking the CTL question as at the date of the NOA, like you must do in this case, future means future from that date. And my lord, this point is important. It explains why there is no reference to the date of the NOA in the statute. This is a point that was made against us in the courts below, but that there is nothing in it. There is no reference to the date of the NOA as a timing point in the statute, because the CTL question has to be asked at different points in time in different cases, and that is dealt with by the common law. My lords, we say, given the careful drafting of the Marine Insurance Act, and we've set out the lengthy history of the process in our written case, given that careful drafting, the word future should be given an interpretation which means that it has some purpose, meaning, and effect. An interpretation which renders the word surplusage or unnecessary should be avoided. Our case is that the word future indicates and connotes that past expenses or past salvage operations are not relevant and cannot be taken into account. My lord, in all of the sort of earlier commentaries in Arnold and in Lord Justice Donaldson's speech, which you've been invited to read and I will ask you to look at again in due course, when they consider this point, they all proceed on the basis that future means not past. And the only question is from what point in time do you take to decide whether something is future or past? That's the basis upon which everyone proceeds until the recent 18th supplement of Arnold, where for the first time a suggestion is made that the word future is inclusionary only. And as I understand the point, the suggestion is that the word was included just to make clear for the avoidance of doubt that you could rank future costs as well as past costs. And with respect, that was then found to be persuasive and accepted by the judge and by the Court of Appeal. And with respect, my lords, we say that is not a persuasive argument at all. It could only make any sense if the position at common law was that clear that past costs could be ranked, but there was some doubt as to whether future costs could be ranked. And in those circumstances, if that were the position, it would just about make sense to include the word future for inclusionary purposes. So for the avoidance of doubt, you can include future costs as well as past. But nobody could suggest that would reflect the common law position prior to the Marine Insurance Act. And we submit for that reason that this inclusionary-only approach that is favoured in the current editions of Arnold and was accepted by the judge and the Court of Appeal is wrong. The word future in our submission, applying the expressio unius principle, indicates that past is not to be taken into account. So, my lords, just to wrap up on our main submission on the wording of the statute, we say, and this is paragraph 30 of our written case, that the reason why pre-NOA costs are excluded is because the question whether the vessel was a CTL must be judged at the date of the NOA, and because section 62.2 makes it plain that for the purpose of the inquiry only future costs are relevant.
Applying the expressio unius principle, are we to suppose that everything other than salvage and general average contribution is to be taken into account, whether past or future?
No, no, my lord.
Well, why isn't what's source for the goose also source for the gander?
Well, my lord, I wouldn't accept that. As I said, the reason why you, in my submission, you have that extra clarification as to what is the cost of repairs is because the items listed, general average contributions and costs of salvage operations, would not ordinarily fall within the common sense meaning of repair costs. So,
The salvage operations would.
Sorry, my lord.
Salvage operations have always been included in repair costs, haven't they?
Well, as a matter, my lord, they have, but as a matter of ordinary language, and bearing in mind this is a codifying statute, as a matter of ordinary language, you would not regard the costs of salvaging a vessel as part of the repair costs. It's nothing to do with physically repairing the vessel per se.
It's the recovery.
Which
precedes the repair.
Exactly, my lord.
And essentially,
So
repair costs, what it actually means, if one looks at the way the law developed throughout the 19th century, it actually means is reinstatement costs. And they may include getting the ship off the rocks.
Yes. Yes. Yes, ma'am.
Because repair actually means reinstatement, that salvage has always been included.
Yes, my lord, I wouldn't disagree with that, but I don't accept the parallel that your lordship puts to me about the expressio unius principle. My lords, just before I move on, can I remind you here, just so that it doesn't get lost, that of the point we make in paragraph 64b of our written case. So obviously our main submission is that the pre-NOA costs generally cannot count, and we say that I'm developing that now, but even if we were wrong on that, you were against us on that, we do say that the language of the statute on any view makes clear that salvage expenses incurred prior to NOA cannot count. And we say, even if we are only right on that point, then that is sufficient for our purposes. My lords, I've been focusing on the wording of the statute in isolation, and I've been submitting that the wording of the statute is clear in our favour. My lords, if there's any doubt on that, if there's doubt about the meaning of the language, then it is legitimate to look at the common law preceding the statute and the understanding of the common law preceding the statute. And that is what I turn to next. My lords, I think it is said against me that you never can get to this stage. I think Mr. Berry says the wording of the statute is so clear in his favour that you can't look to the common law. My lords, I certainly wouldn't accept that. I say it's clear in my favour, but at worst for me, there is doubt, and therefore it is appropriate and legitimate for you to look at the common law. Now, my lords, can I turn to the prudent uninsured test? There is no doubt that this test continues to be relevant and continues to apply after the Marine Insurance Act. We say that the test properly understood supports the view that only future costs from the date of the NOA are relevant for the purposes of the CTL inquiry. The prudent uninsured test is purely forward-looking, and at the date to which the inquiry relates, one asks whether the hypothetical owner would, if uninsured, have gone to the future expense of recovering and or repairing the vessel instead of leaving it where it lies. And in answering that question, we say that expenses which have been previously incurred prior to the NOA, before the relevant date of inquiry, are logically irrelevant. And my lords, can I just ask you to turn up the Blairmore case, which is in the Authorities, Volume 1, Tab 12. Sailing ship Blairmore and Macready. Now, page 537, my lords, the head note. This was an extraordinary case in which the vessel was a CTL looking forward at the date of the NOA. But what happened was that the underwriters, the insurers, themselves paid for the vessel to be salvaged. At the time, they paid a very large amount of money for the vessel to be salvaged before the proceedings were commenced. And their argument was that the vessel was not a CTL at the date of the commencement of the proceedings because they had got the vessel off the rocks and given it back to the assured, and all that the assured had to do from that point was to repair the vessel. And purely the costs of repairs were not greater than the insured value. And what the House of Lords say is this is not possible. The insurer itself cannot upset the apple cart in this way by taking steps itself to render what was otherwise a total loss a partial loss, because that just goes contrary to the bargain between the parties. So that's what the case holds. But, my lords, can I just refer you to two parts of the judgment where the prudent uninsured test is stated? Could you look in Lord Watson's judgment at page 547? And just by the top hole punch on 547, my lords, Lord Watson refers to the fact that the ship had sunk in a depth of water which admitted of her being raised to the surface and repaired. And my lords, can I just ask you to read the balance of that paragraph down to the reference to Irving and Manning? So, my lords, can I show you another short passage in Lord Shand's judgment? If you turn to page 556, please. Again, just level with the top hole punch. Lord Shand says the test of whether a constructive total loss has or has not occurred is to be found in the answer to be given to the question, what would a prudent owner do if not insured? If such an owner, having regard to all the circumstances, would abandon his vessel and would not attempt to raise and repair her, because the cost of doing so would exceed her value when thus restored to her former condition, a constructive total loss has been incurred. So, my lords, those are statements of the prudent uninsured owner test. We say that they are focusing on expenses to be incurred in the future from the relevant date of inquiry, not on any expenses that have already been incurred by the insured. And one asks, at the date to which the inquiry relates, so in our case, at the date of the NOA, whether a ship owner would have gone to the expense, future looking, of repairing the vessel, or whether he would have left it where it lies.
Why does it follow from that that the owner, the prudent uninsured owner, would ignore past expenditure?
It follows from what I say the test is, my lord.
Why does it follow?
Because the test, you ask the test at the relevant date of inquiry, and the test is forward-looking. And you are focusing on the actual condition of the vessel, the actual situation of the vessel at the time that you ask the question. And therefore, what has happened in the past is logically irrelevant.
Why is that? Because surely the prudent uninsured owner says to himself, well, this ship is worth 5 million. I've already spent 3 million. And if I spend another 3 million, which is what it will take, I'm frankly left with worth. So I'm going to give up and claim for a partial loss. That's what the prudent uninsured owner wouldn't say. Okay,
he's uninsured, so there's no question in his mind of giving up a claim for a partial loss. That's the premise of the test.
So you say that because at that stage another 3 million will get him 5 million worth of ship. He says, well, the money I already spent is down the drain anyway, so I ignore that.
As a prudent uninsured owner, my lord, yes. Yes, and my lord, the point is illustrated by the example that we give in paragraph 36 of our written case on page 65 of the core bundle. Now this is my lords, this is an example that we gave, I think, in identical terms, if not in identical terms, in substantially the same terms, both before the judge and the Court of Appeal, and neither of the courts below grappled with it, but it is important to grapple with it because we say this illustrates the correct approach.
Which paragraph? 36.
So, my lords, I'm not going to read that out, but we say that example is powerful and it explains why our argument is correct. And, my lords, can I just... I've asked you to read the Lowndes and Rudolph extract. Can I just ask you to note specifically that an almost identical example is given in Lowndes and Rudolph to support their views? Now, in a sense, that is fortuitous because neither of the parties had picked up on the Lowndes and Rudolph commentary before. But the same sort of example is given there, and we say it strongly supports our submissions. Now, reverting to the to the prudent uninsured owners test, and I think this is picking up on Lord Sumption's point just now to me. In their written case, the respondents say at paragraph 84 that we ask a rather different question, or that a different question should be asked, that is, whether the ship owner would spend more on his ship at the date of the NOA. So, taking into account what he's already spent, does he spend more? And that is the relevant question. So the respondents say, we submit that that is not correct. For the reasons I have given, the previously incurred costs are irrelevant to the test that is to be applied. The prudent uninsured owner must ask itself, as at the date of giving NOA, whether it is worth incurring in the future the costs necessary to repair the vessel. And my lords, on this same point, paragraph 85, or similar point, paragraph 85 of my learned friend's written case sets up a straw man. It is not our case that the test is whether a prudent uninsured owner would, looking to past expenditure, throw a given amount of money, good money, after bad money. That's not our submission as to what the test contemplates, and my learned friends are just wrong to suggest otherwise.
But the alternative view would be that the prudent uninsured owner test is concerned with the reasonableness of incurring expenditure, and that you therefore, though you ask the question at the time of NOA, the question that you ask is whether it was reasonable to incur the expenditure at the time it was incurred. So that you ask, if expenditure has already been incurred, e.g. on salving the vessel, would a prudent uninsured owner have salved the vessel at the time when he committed himself to doing so?
My lord, that alternative view, as you put it, doesn't find any support in the cases, certainly none that we can see.
Does it find any? Has anyone rejected it?
My lord, it is. I'll show you. I'm going to come to the common law position now. It is inconsistent. The alternative view is inconsistent, obviously with Carver's presentation, but also with the cases that I will show you. And my lords, we would also submit that the passages in the Blairmore case, in particular Lord Watson's judgment that I have shown you, are inconsistent with the alternative view Lord Sumption has raised as a possibility. My lords, turning to the position at common law prior to the Marine Insurance Act being enacted, our submission is that it was trite law in England and also in the USA that as a matter of principle, expenses incurred prior to the date of the NOA could not count towards a CTL calculation. Now, we rely obviously upon the presentation by Mr. Carver that we have referred to. My lords, this was a very serious presentation to a very serious and august body for a very serious purpose, namely the formulation of international marine insurance rules, which the International Law Association hoped would be widely adopted in contracts of insurance, just as their York-Antwerp rules are widely adopted in contracts of affreightment. And my lords, we have set out most of the key parts of the presentation in our written case. My lords, can I ask you, I'm not going to spend time on it now, but can I ask you in due course to look at the presentation in the original, and I'm going to give you the references. It's in tab 72 of the Authorities Volume 2, and the presentation begins at page 1483. And I think the material part that I would like you to read in the original begins at page 1499. And just over half the page, halfway down the page, my lords, there's a paragraph starting, I come now to the question, when ought the test for CTL to be applied? So I would ask you to read from there through to page 1502. And it's really just to the end of that first paragraph on 1502, about 6 or 7 lines down. And my lords, the key points that come out of the presentation are these. First of all, that the CTL test is to be applied at a particular point in time. Under some systems of law, the relevant time is the date of the NOA, and only the date of the NOA in a case like ours. So in America, you do not ask the CTL question also at the date of the commencement of the action. It's sufficient the vessel is a CTL at the date of the NOA. Under the English system, it is also necessary to ask the CTL question at the date of the commencement of the action. So, as Lord Justice Donaldson puts it in his speech, there are two relevant dates: date of the NOA, date of commencement of the action, if later. And for the purposes of the, just for context, my lords, for the purposes of the marine insurance rules that were proposed and subsequently enacted after much debate and consultation, the critical date was chosen as the date of the NOA. So favouring the US rule rather than the English rule. The second point, my lord, that comes out is that expenses previously incurred before the critical time are to be ignored, because the question is whether the ship as she lies at the critical time is worth recovering and repairing. That's the critical question. The focus is on the state of the ship at that time, the present state of the ship.
How does that work, Mr. Ashcroft, in circumstances where you have to salvage or you have to carry out some works in order to find out the extent of the damage?
My lord, I'll come on to that, but what we say is that the assured can always tender a CTL at the very first moment if it wishes to claim for a CTL if the facts... Sorry, the assured can always tender an NOA from the very first if it takes the view that it would like to claim for a CTL if the facts justify that claim.
What's the position if it's not a CTL when the notice is given, but subsequent information arrives which shows that it has become one? Do you have to serve another notice? You have to serve another notice.
My lord, you do. That point is covered in Lord Justice Donaldson's speech, and I'll give you the reference to it in a moment when I get to that point in my submissions. But yes, if the situation is that the position is developing and the vessel is not a CTL at the outset but becomes a CTL because the position deteriorates, the original NOA is invalid because the vessel was not a CTL at that time. You need to serve a further NOA without prejudice to the first.
Practice happens. I mean, it's very common for a situation to deteriorate, the weather gets worse, the salvage proves more difficult than was anticipated, and so on. In practice, do people serve successive NOAs just in case the earlier one may have been given at a time when the facts did not seem so good?
My lord, I can only speak of experience from cases that I have been involved in rather than more general practice, but I have certainly seen successive NOAs tendered in cases without prejudice to previous ones. I will refer you to the passage in Lord Justice Donaldson's talk, where he speaks of exactly that sort of practice and recommends it.
Coming back to the answer to my question, do ship owners actually serve protective NOAs in those circumstances?
My lord, yes, I believe so, and they are encouraged to do so by both the textbooks and average adjusters, and I will give you the references to that.
Quite a dangerous thing to do, because the insurer might accept it and take the ship.
My lord, the insured would be delighted if that happened.
Well, that would depend
in
on the
almost
facts.
every conceivable case. I mean, that is not, with respect to a good point against us. It was a point that was made by the judge, but not by the Court of Appeal.
Right.
And I'll come back to it. But because a CTL claim is almost always in the insured's best interests, if he can claim for a CTL, he will want to. The point that if he chooses to give an NOA, he has decided that he would like to claim for a CTL if he can. That's the premise of giving it. And if the insurer accepts that, he would be delighted. My lords, I'll come back. I was going to mention this in a moment, but can I give you the reference now, just for the transcript? In Professor Rose's book on marine insurance law and practice, which is in tab 60 of volume 2, page 1396 of the bundle, paragraph 24 and 10. Professor Rose says, where it is unclear whether or not or when a constructive total loss has occurred or a notice of abandonment has been validly communicated, it may be appropriate and advisable for the assured to give a succession of notices of abandonment. And my lords, I'll give you the reference also to a similar statement in Lord Justice Donaldson's speech, and also a statement by the chairman of average adjusters to similar effect in a moment. And my lords, the third point that comes out of Carver's presentation is that if one were to take account of precedent events or precedent expenses, so expenses prior to the NOA, then that would amount to assessing the costs of recovery and repair at the time of the casualty on the conditions existing at that time, rather than at the date of the NOA or the date of the commencement of the action. And as Carver said correctly, no system of law does that. It doesn't assess the costs and recovery and repair at the time of the casualty. Now, my lords, we set out in some detail in our written case, in particular in paragraphs 41 and 42 and footnotes 40 and 30, those who will no doubt have focused very thoroughly on Carver's speech and his proposals over the course of several years following the Buffalo Conference. There was another conference in Rouen in 1900, and then there was the Glasgow Conference, at which the Glasgow marine insurance rules were enacted. And there were debates and discussions about the presentation and about the proposed rules at the Buffalo Conference in Rouen and in Glasgow. The fact is that there were extremely distinguished lawyers present on those various occasions, including several judges of the English court and several judges of the Scottish court, many distinguished practitioners, many distinguished American lawyers. And we have the records of all of the discussions and all of the debates, and there is no hint, there is not one hint anywhere of anybody expressing a disagreement with Carver's statement of principle on this point. A doubt or a disagreement. My lords, more than that, the presentation was referred to in the leading textbooks on marine insurance, including both Arnold and Chalmers. without any doubt or query whatsoever being expressed in relation to the key point of principle. My lords, can I just give you the references? The reference in Arnold is volume 2 of the authorities, tab 40, page 1262, and the reference to the Carver paper is on page 1263. So the authors of that text at the time, who were Edward Louis de Hart and Ralph Symey, had obviously read the Carver presentation. They refer to it in their text. We've been through the whole of that text. There is no doubt or query expressed in the text about what Carver said about this statement, and said in very clear terms about this statement of principle. The other reference in the textbooks, my lords, is to Chalmers. Now, as you will know, Chalmers was the draftsman of the Marine Insurance Act, and he produced a digest of the law relating to marine insurance while the Act was being drafted in 1901. So a few years after the Carver presentation, while the Marine Insurance Act was in its long drafting process. And he refers to the Carver presentation in that text and calls it a valuable paper, in which Carver discusses the English and foreign laws as to constructive total loss. And my lord, the reference to that is volume 2 of the authorities, tab 50, page 1345. And then, my lords, following the publication of the Marine Insurance Act, the enactment of the Act, Chalmers updates his book, and it's not now called a digest of the law relating to marine insurance. It's called the Marine Insurance Act, 1906. And we have that in tab 51 of the authorities bundle, my lord. And we have the same reference to the Carver paper. C2, a valuable paper read to the ILA by Carver, in which he discusses the English and foreign laws as to constructive total loss and suggests a particular definition. So that, my lords, that is page 1348 of your bundle. Now, my lords, if the accepted common law position was not, in fact, as Carver had set out in very clear terms in his presentation, obviously, one would have expected Mr. Chalmers or the editors of Arnold to say so. It's really inconceivable that that was not the generally accepted position in the circumstances, given, as I say, the lack of any adverse comment or doubt throughout the consultation process relating to the Glasgow marine insurance rules, and then what we see by way of the reference to the Carver paper in the leading textbooks, English law textbooks at the time. And my lords, the reason why we say this was generally accepted is because it simply follows logically from a proper application of the prudent uninsured owner test. Now, my lords, I wanted to show you the American cases, which are precisely in point. We rely on strongly. The first is Humphreys, which your lordships will find in the second authorities bundle, volume 2, tab 35. Now, tab 35, my lords, this is a decision of, I will say, the great Mr. Justice Story, sitting as an Associate Justice of the Supreme Court. He was an Associate Justice of the Supreme Court of the USA already by this stage, that he was sitting in the Circuit Court for Massachusetts, Boston. And can my lords just read the head note, the first 6 or 7 lines or so. And just the first held, please. I don't think the rest is relevant for present purposes. And, my lords, can we then turn to page 1209? Halfway down the page, my lords, you see the submissions by Peabody, the counsel for the plaintiffs.
What's the internal page numbering? Because the...
I apologise, my lord, 433.
Okay, thank you.
It's too dark at the bottom of the page, is it?
Seems to have given. It is there. It is there.
I will use the internal for present purposes. 433, my lords. Could you just read from upon the report of the auditors Peabody submitted down about 10 lines to the sentence starting that the auditors were wrong. I don't need you to read the second point. My lords, can you then turn over the page, so 434 internally, again halfway down, Webster for the defendants contended, and can you just please read what he contended in relation to point 1? And my lords, if we then turn to page 435 internally, and the judgment of the court given by Mr. Justice Story.
I beg your pardon, which page? Oh,
page 435 internally, my
yeah,
lord. 1211 at the bottom, if you can read that.
Yep, thank you.
And my lords, the first question is as to the right of the plaintiff to recover for a total loss of the vessel. She sustained an injury, the repairs of which cost more than half the value. Okay, can I just pause there, my lord? The reference to half the value is explicable by the rule in America that you have a CTL if the costs of repairs exceed half the value of the vessel rather than the full value. And you can see that rule considered in the Carver presentation as well. But that's why there's a reference to half the value. A bottomry bond was executed to secure the payment of the amount of the repair. She sailed on the voyage and safely arrived at Boston. The abandonment was made while she was on the high seas in the prosecution of her voyage in good safety, a few days only before her arrival in port. Moving down, under these circumstances, the question arises whether the abandonment was valid so as to bind the underwriters. It has been settled in the courts of the United States that an abandonment is not good unless the loss is in fact total at the time of the abandonment. We say the same as a matter of English law. The state of the information or the existence of the total loss at an antecedent period, if it has no longer a continuance, gives no title to abandon. And when once the right of abandonment is fixed and acted upon, no subsequent events which change the total into a partial loss have any effect to divest the antecedent right of the parties. Such are the principles decided by the court, whose judgment I am bound to follow. And as far as I have knowledge, they have received the sanction of the state tribunals, and so on. Applying this doctrine to the present case, how can it be said that at the time of the abandonment there was a total loss? The vessel was physically safe and in good repair. She'd been repaired. The voyage was not lost, for it was then in a successful progress and was afterwards accomplished without further loss. It is true that the vessel has been injured more than half her value, and if the owner had then elected to abandon without repairing her, he would have been justified by the established law on this subject. And then moving down about 10 lines, my lord, if there had been no bottomry bond given for the repairs, there would be no pretense to say that the loss was total.
Just pausing there, his reasoning is effectively that the owner has elected up to the point where the bottomry bond was issued to treat it as a partial loss. Is that not right?
No. No, I wouldn't accept that, my lord. He's saying that he's saying quite the opposite, that the focus is upon the situation at the time of abandonment.
Why does he say
and nothing occurred?
No bottomry bond given for the repairs, there would be no pretense to say that the loss was total?
My lord, we need to read on, but the point that was being argued, I think, was that because there was a bottomry bond that had to be discharged, you would have to pay to get the vessel back, then that could be regarded as something in the future. So what he's saying, if there wasn't the bottomry bond, there couldn't have even been an argument for the owners in this case, because the vessel has been repaired, and therefore looking at the position as at the date of the NOA, there's no CTL. He goes on, but it is said that the bottomry bond constituted a lien which encumbered the vessel, and that she never came free to the possession of the plaintiff. The existence of such a lien is not per se a cause of abandonment. The vessel is not either technically or physically lost by it. It continued during the voyage, a contingent right. And then moving down a bit, in the present case, 5 lines or so, in the present case, the bottomry bond was not at the time of the abandonment a fixed and absolute lien. Carries on. And he says why the ultimate loss was the act of the owner himself in not paying the bond after the successful termination of the voyage. So the bottomry bond doesn't provide an answer. That's his reasoning. And over
this
the
seems to be authority for the proposition that if a ship is totally lost as a result of a security interest being enforced by its holder, by the holder of the security interest, insured peril. That seems to be the ratio.
well,
Or how that helps us.
no, my lord, the ratio is that the costs of repairs themselves cannot be taken into account because they have been done, they have been incurred prior to the notice of abandonment. And he then deals with the separate point in relation to the bottomry bond. And he said the case advanced by the plaintiffs in relation, this is a separate point, this case advanced by the plaintiffs in relation to the bottomry bond does not work either. And the reasoning, my lord, is that the loss was not occasioned, in relation to the bottomry bond point, that the loss was not occasioned by any peril as a matter of causation. The loss was because the owner did not pay the bond himself.
The reason surely given by Judge Story for saying that the repair costs could not justify a total loss is that, as he puts it halfway down page 436, the owner had then elected to abandon without repairing her. He would have been justified, but the owner was not bound to abandon. That's why I suggested to you that this is a case in which the owner had effectively elected to treat this as a partial loss. He hasn't abandoned. He's had it repaired, and that's been treated here, rightly or wrongly, as an election.
No, my lord, no. With respect, the argument being made is that these are costs that have been incurred and therefore can be taken into account. And the judge says no. You've got to read the first part of his judgment, that one has to look at the position at the time of abandonment. And it's that paragraph, my lord. He says the state of the information or the existence of a total loss at an antecedent period if it no longer has a continuance, gives no title to abandonment. And once the right of abandonment is fixed and acted upon, no subsequent events can change the position. So that's
What he's saying is there was a CTL at an earlier stage, but the owner elected not to treat it as such, and therefore that's water under the bridge.
The next page seems to support that view, because at 437, about a third of the way down, it says, in point of fact, however, the subsequent loss of the vessel was not occasioned by any peril insured against causa proxima non remota spectator. The ultimate loss was by the act of the owner himself in not paying the bond. So what you had is a situation, not like the one in the present case, where part of the costs have been incurred and parts have still to be incurred. What you had is a repaired vessel, and the cost of the repairs were eventually not paid for, and the cause of the loss was the failure to pay the bottomry bond.
My Lord, the question that Mr. Justice Story asked, and this is page 436, the second paragraph, applying this doctrine, which he has just stated, to the present case, how can it be said that at the time of the abandonment there was a total loss? That's the question he's asking himself, and he says there can't be, because the vessel has been repaired. And if you then turn on to page 438, the final sentence of the first paragraph, my opinion on this point is that in no legal sense was the loss total at the time of the abandonment, and therefore the plaintiff is not entitled to recover for more than the partial loss. So the case is absolutely not one about an election to claim for a partial loss because you've done repairs. That's not part of the reasoning at all.
What's the partial loss? The partial loss surely is the repairs that the owner elected to carry out instead of abandoning the ship to the underwriters. That's the point he makes 2 pages further on, and he is restating it here.
My Lord says there is still a partial loss claim in respect of the repairs, but there's no CTL claim because the vessel was not a CTL at the time of the abandonment. But, I mean, my Lord, so there is, I'll show you how this is treated in subsequent cases in the textbooks, but this is a case directly in point, and it cannot be, the reasoning cannot be explained on the basis that Lord Sumption contemplates. It is not a case about losing what would otherwise be a right to claim for a total loss because you've elected to claim for a partial loss. The claim is for a total loss, and the reason it was disallowed was because the vessel was not a total loss as at the time of the NOA, because it had been repaired.
But that is not totally in point, for the simple reason there had been total repair, it wasn't a loss. In this case, it is not talking about some losses having been incurred and others still to be incurred. What you've got is, as you say at 436, a statement of the doctrine of the time of assessment. But beyond that, the facts differ.
Yes, Manuel, but the ratio of the decision is that the costs of repairs cannot be ranked in the CTL calculation because they were incurred prior to the NOA. My lords, there's another US case in tab 36 of the bundle, which is Dickey and the American Insurance Company. And my lords, can I just ask you to read the first paragraph on the first page, page 1220. Mm-hmm. So, my lords, this is a case where some repairs are done before notice of abandonment is given. And can I ask your lordships to turn to the judgment of Mr. Senator S. Allen on page 1224. The judge says this is an important case, and I've taken some pains to ascertain from the limited means within my reach the general principles which have governed in deciding questions similar to the one under consideration. It appears to be a general rule that the right to abandon must depend on the situation of the thing abandoned at the time the offer is made. Thus, if a vessel shall be captured, detained by embargo or seized, and she shall be released or restored previous to abandonment, the right to abandonment is lost by the fact of restoration. I have not been able to discover any decision of the courts of this state embracing precisely the same state of facts of the case under consideration. But the principle involved in cases of capture and restoration appears to me equally applicable to cases by shipwreck and restoration by being repaired. The ground upon which the decisions are based, as I apprehend, are that no abandonment can be valid so long as the thing insured is not taken from the control of the owner, as it would be if the detention by capture, embargo or shipwreck existed at the time of the abandonment. In the case of capture, a restoration previous to the time of the abandonment takes away the right to abandon. And upon the same principle, in the case of shipwreck, the vessel having been repaired before the abandonment and thus restored to a state which enables her to perform all that was warranted by the insurers, and although the fact was unknown by the assured, he still loses his right to recover for a total loss. The principle is clearly recognised in the case of Humphreys, which is a case we've just looked at. I submit that is a correct interpretation and application of the Humphreys decision. And my lords, can you just read to yourself the last paragraph on the page as well?
Under the circumstances of this case?
Under the circumstances.
Yeah.
Can I show you the way that these cases are dealt with in the leading US textbook of the time? And that is in tab 62. Treatise on the Law of Marine Insurance by Mr. Parsons, a professor of law at Harvard. Page 1400. If at the time the abandonment is made, the master has commenced to repair, so it's not a question of completing repairs. If the master has commenced to repair, the abandonment is invalid and the assured can only recover for the expenses incurred, although it exceeds half the value of the vessel. And then the footnote explains this. This proceeds on the ground that the state of facts existing at the time of abandonment determines the right of the assured to abandon, citing Humphreys and Dickey. So it's not a question of electing only to go for a partial loss because you start the repairs. That is not what these cases say.
Well, isn't it? I mean, that's certainly what the text appears to say, and I would read the footnote as making the same point about Humphreys as I and Lord Hodge suggested to you a moment ago, which is that it was a case which was regarded, rightly or wrongly in the light of English law, as one where there was an election to treat it as a partial loss.
My Lord, my submission is that...
Because that election had occurred before the notice of abandonment, the notice wasn't justified. That's what he appears to be saying here.
No, my Lord, he says the cases proceed on the ground. He states that the question involves looking at the facts existing at the time of the abandonment. That's his analysis of the cases, and my submission is that is correct.
Yes, the facts of the time of abandonment were that the owner had elected to treat it as a partial loss.
That's with respect, my Lord, that is not the reasoning in the cases. The question that Mr. Justice Story asked himself was the vessel a total loss at the time of the abandonment? And he says no. He doesn't say it was a total loss at the time of the abandonment or at some earlier time, but the insured has elected not to claim for it. The question he asks is inconsistent with the election analysis. Now, my lords, that's the US authorities, and we say they are in point. Can I remind you that the Carver presentation was addressed to an English and US audience, and none of the US lawyers suggested that what Carver said as a matter of principle was wrong, and that would be entirely consistent with these US cases having the meaning and effect that I submit. Turning to the English cases, my lords, the first case is Hall and Heyman, and I want to deal with this briefly. We address it in paragraphs 46 and 48 of our written case. And the courts below have, the courts below and the respondents on this appeal treat the fact that the case proceeded on the basis of a concession as if it were somehow a factor against us. But my lords, in my submission, the opposite is true. That the concession was made by such an experienced senior counsel only serves to emphasise that it was, as we submit, regarded as trite law and well understood that pre-NOA costs could not be ranked towards the CTL calculation. And of course, the concession fits entirely with Carver's presentation that had been produced and circulated only a few years before. Now, my lords, I just wanted to show you one part of the judgment of Mr. Justice Bray. It's tab 14 of the volume 1, page 587. 587, sorry, my lords, apologies, 588. Can I just, for context, the NOA in the case was served on December the 9th, and that's why you see a reference to December the 9th in this section. And what Mr. Justice Bray says is, in estimating the cost of repairs, I do not think I have anything to do with the underwriters. That's one point. But he says, it is all upon the assumption as to what a prudent uninsured owner would do. And I have to see whether on December 9, that's the date of the NOA, the cost of repairs, as stated in the Act, including those items which are mentioned in the Act, would or would not exceed the value when repaired. I cannot take into consideration anything that was done before, which is a matter of fact neither improve the position nor worsened it. So my lords, that when Lord Sumption asked me earlier, is there an English case which sets out the principle that we contend for? Yes, there is. There is Hall and Heyman, decided 5 years after the Marine Insurance Act was came into force, applying exactly what we say the test is. You look at the position as at the date of the NOA, and you apply a forward-looking test, asking whether the prudent uninsured, what would the prudent uninsured owner do, looking forward from that date. Now, my lords, so far as the researches of counsel in this appeal are concerned, the position is that Hall and Heyman was not doubted on this point in any previous case prior to the present case. And so far as we can tell, my lords, no English law textbook cast any doubt upon Hall and Heyman on this point until the early 60s, when the editors of Arnold started to query the point. My Lord, the second case is a decision of Mr. Justice Roskell in the Medina Princess. It's a very long judgment, and we've only included part of it, the relevant part of it, in your bundles at tab 47. And my Lords, I'm not going to spend long on it, but this is a case decided in 1965, so after Arnold had started to query for the first time the point about whether pre-NOA costs could rank.
Tab
Sorry, tab.
47, did you say?
No, that's not.
I've landed up in the middle of Benyon on statutory interpretation.
Thank you. I'm so sorry. Tab 20.
23 of part 1.
I'm sorry, it was tab 23. So it's a decision of Mr. Justice Roskell, as he then was, the point of principle is decided in relation to item 25 of many items that the judge considered in his judgment. It was a claim to rank the costs of steering engine and telemotor control repairs. And on page 751, you can see that the judge says a great deal of time was spent at trial investigating this item, which involves only a comparatively small sum of money. And moving towards, he talks about what the costs were, and he comes up with a figure of £420. And then towards the bottom of the page, he says, Mr. Brandon, however, rightly pointed out that this figure, even if allowed, is inadmissible, both for the purposes of the claim for CTL and for their claim for partial loss as originally pleaded. It is inadmissible for the purposes of constructive total loss claim because the work was done before the date of notice of abandonment. And so, my Lord, there's a submission by Mr. Brandon, as he then was, that these costs could not rank because they were incurred prior to the notice of abandonment by the insured. That submission is accepted by the judge. Now, of course, it's right to say that there isn't a detailed analysis, there isn't a record of what the arguments were on the point, but it's exactly in point and it's exactly in our favour. And again, if anything, we would rely upon the lack of detailed analysis and reasoning because we say this simply reflects the trite law and a proper application of the prudent uninsured test. Now, my Lords, the only other case that is of any potential relevance as a matter of English law is the Yarrow Carus. And I'm going to wait to see.
That's the case in which Lord Porter didn't decide it.
My Lord, he didn't decide it, and his judgment is set aside by the Court of Appeal. And we say you don't get any assistance out of that case at all. He said, I don't need to decide this point. The only other point I would make about the case is that actually his analysis and conclusion is that the salvage costs can rank because he treats them as future to the NOA. He says you would have had to pay, the vessel was still in the possession of the salvors.
Because they had a lien.
They had a lien, it was in their possession, and you couldn't have got the vessel back without paying them. Therefore, he says you can rank them because they're future costs. So actually, his decision proceeds on the basis that they need to be future. He sort of ducks the question as whether they could be passed.
It's very odd because it suggests that something that would not otherwise be relevant to the CTL becomes relevant by the mere act of securing it on the hull.
I would agree with that, my Lord.
In principle, that can't be right.
I would agree with that. My Lord, I wanted to say we have a section in our written case headed "The Considerations of Justice," and I wanted just to say a little bit about this. We rely upon what we say in writing, but in our submission, the position for which we contend as a matter of law does not produce any unfair or unreasonable or unjust results. On our case, the insured can only seek to rank expenses towards a CTL calculation after he has given NOA to the insurer. And the NOA gives the insurer the opportunity to accept it if he wants to, and determine that expenses should not be incurred. So he can, if he wants to, take over the situation and control it going forward. The NOA gives him that option. And at the very least, he is on notice as a result of the NOA that a casualty has occurred, and he can supervise and investigate that casualty if he sees fit.
Would he have to, he's not obliged, as I understand the law, to take over the ship, even on a valid abandonment. He simply has the right to do so.
Yes.
If he wished to make decisions regarding its future, he'd have to take over the ship.
Yes, well, I think the position, my lord, is if the insurer accepts the abandonment, he doesn't take over. That doesn't necessarily mean he takes over the legal title to the ship. But I can check the position, but I think it then does mean that the insurer can control what happens with the ship.
Without asserting a right of possession.
Without asserting legal title. But my lord, can I double check that and come back to you on it?
Would the insurer, if he did that, become liable for the liabilities associated with wrecks, such as wreck raising expenses and pollution liabilities?
I think that is primarily the reason. Again, I'll check, but I think that is primarily the reason stated in the text why insurers hardly ever accept a notice of abandonment, because of a concern that it will give rise to different liabilities in relation to the wreck. So, my lord, the position is also, let's not forget this, that pre-NOA costs, even if as per our case they cannot be ranked to a CTL calculation, that doesn't mean that the insured can't ask for them to be paid. He just can't include them in his CTL calculation. And in many cases, this is the point that Carver makes in his presentation, in many cases, an insured can recover pre-NOA costs as sue and labour expenses. So it's not that he's out of pocket, it's just that he can't rank those costs to the CTL calculation. And we, my lord, we say that strikes a perfectly fair and reasonable balance between the interests of an insured and insurers. And more than that, my lord, and I'll come on to this in a moment, but more than that, the assured can always act to ensure that expenses can be ranked by tendering an NOA as soon as any serious incident occurs. If he wishes to maximise his chances of claiming for a CTL, and if he follows the guidance in the textbooks and from average adjusters, that is what he will do. He will tender an NOA immediately because that maximises his chances of claiming for a CTL. It's precautionary. And if he is able, in due course, to establish that the facts justified the giving of the NOA, he claims for a CTL. He wins. So, my lords, we submitted is just wrong to suggest that our case results in any unfairness or injustice. My lords, to some extent I've covered these points in passing, but I want to run through them quickly and address some of the main points that were made against us and accepted by the courts below. So it's sort of a bit by way of recap, but I hope it will be helpful or at least not unhelpful. And my lords, can I pick up first on paragraph 1 of the respondent's written case? My friends say that the case is about whether you can imply exclusions into the policy wording and into the Marine Insurance Act. It's just not right. It assumes what it needs to prove, namely that the wording expressly allows costs of repairs to rank towards the CTL calculation, even if they are incurred before NOA is served. And we say the case is about giving proper effect to the statutory and contractual language, and I'll come on to the contractual language, properly understood, and in particular applying the CTL test at the correct time, the date of the NOA. Now, just coming on to my lords, the Court of Appeal's reasoning in relation to the word future in section 62, subsection 2, we address this in our written case, paragraphs 56 to 59 and 62 to 64. And my lords, I do emphasise the point, this is on the inclusionary only wording. The point we make in paragraphs 55 to 60 of our written case is that prior to the 18th edition of Arnold, nobody suggested that future could or should be read as inclusionary only. The argument was that it properly meant future and not past. The suggestion in Arnold and in Lord Justice Donaldson's extrajudicial speech was that it meant future from the date of the casualty, because it was suggested that the CTL had to be assessed at the date of the casualty. And my lords, we say that that's just wrong. The CTL is not to be assessed at the date of the casualty. So, yeah, my lords, perhaps realising the difficulty with the original argument, the supplement to the 18th edition of Arnold makes the suggestion that the future is a word of inclusion only, and it is that argument that appealed to the judge and to the Court of Appeal. And my lords, as I've said, we submit that inclusionary only approach is not persuasive and should not be accepted. My lords, the Court of Appeal said that the word future was problematical also on our wording, so perhaps implying that it was problematical for the respondents to this appeal, but also they said problematical for us. And my lord, we addressed that in our written case, paragraph 64, and I'm just going to rely upon the points that I have made there. The three reasons that the Court of Appeal gave for saying that the word was problematical for us are not good reasons for the particular points that we set out there. My lords, can I deal next with the Court of Appeal's reasoning in paragraph 72 of the judgment? So that is tab 6 of the core bundle, page 163. And my lord, this is really by way of recap, but we submit that it is irrelevant and not a point against us that the Marine Insurance Act does not say in express terms that some costs should be ignored. That was the point that the Court of Appeal was making. We say that simply follows from the fact that the CTL test is forward-looking and the test has to be applied at different times, including the date of the NOA in this case. So it simply follows from an application of the forward-looking test from a particular point in time that costs incurred prior to that time are not relevant. As to paragraph 73 of the Court of Appeal's reasoning, my lords, we address this in paragraph 66 of our written case. And again, by way of recap, really, there is nothing in the point that the statutory section makes no express reference to the NOA. And that is because the section says nothing at all about the time at which the test is to be applied. And as I've said, one looks to the common law for guidance on that in any particular case. My lords, underpinning and driving, I think, much of the Court of Appeal's reasoning on this point seems to be an assumption that an assured cannot give an NOA properly at an early stage. And you see a reference to that in paragraph 74 of the Court of Appeal's judgment. They talk about costs being incurred all before the insured could properly give NOA. Now, the Court of Appeal does not state or define anywhere in the judgment the circumstances which define when an NOA can or cannot properly be given. The issue is just left unclear in the judgment. But, my lords, if we look back at paragraph 57 of the judgment in the final paragraph, this is dealing with the timeliness of the NOA point, which we lost on and is not before this court. But paragraph 57, final 3 lines, my lords, the Court of Appeal said that the judge was entitled to conclude that the owners still did not have reliable information of the loss as at the time that the NOA was given on the 1st of February. Now, my lords, given that the Court of Appeal held that the NOA was valid, that was the main point, it is plain that they cannot have had in mind that an assured is unable properly to give an NOA unless and until it has reliable information of the loss. But as I say, we're left in doubt as to what they did mean on this point. The respondents' own take on this matter, my lords, is clear from paragraph 30 of their written case. And they suggest that an NOA cannot properly be given until, quote, precise damage assessment and cost of repair assessment can be made. And that is one of the reasons why they submit that our case would work in justice. But, my lord, their key contention is that an insured cannot give a precautionary NOA before it begins to incur costs, because, they say, such an NOA would be invalid, and they suggest inconsistent with the duty of good faith. Now, my lords, as to that, it does seem doubtful that the respondents really are contending that an insured cannot give a valid NOA prior to receipt of reliable information of loss, because that would be self-defeating. It would mean that the only NOA that they gave in this case was invalid. Separately from that, no textbook and no case supports the idea that giving a precautionary NOA would be contrary to the duty of utmost good faith. This is a new submission that was not advanced in the courts below. It is unsupported and it is wrong. My learned friends rely on the Yarrow Caris, but the judgment of Mr. Justice Porter was set aside and he didn't grapple with this point. And in fact, the clear position as a matter of law is that an insured can give an NOA from the earliest stage. And if he can prove subsequently that it was justified by the facts at the time it was given, it is valid. And my lords, can I just show you, or can I give you the reference, please, to Lord Justice Donaldson's speech on this? It is volume 2 of the authorities bundle. Tab 65. page 1427. And my lords, 1427, my lords will see a heading halfway down the page, time of notice of abandonment. Start, and the second paragraph, but can a notice of abandonment be given too early? My lords, I ask you to read all of that. In summary, what Lord Justice Donaldson says is that it can be too early in the sense that it can be before the vessel is in fact a CTL, but otherwise there is no limitation. The assured can, in Lord Justice Donaldson's words, chance his arm and give notice of abandonment, hoping that he can subsequently prove that it was an NOA. And my lords, we say that that is indeed correct. My lord, the same point is supported by the decision of Mr. Justice Roche in the George Cohen case, which we refer to in footnote 85.
That passage at 1427, he is discussing Scottish law and law of most foreign countries, as he says. It's over the page. He begins by saying, begins the discussion of English law. Unfortunately, the matter is more complex than English law. I think perhaps we'd better adjourn at that point, Mr. Ashcroft.
Yes, of course.
And we'll look forward to hearing you again at 2:00.
Thank you, Madam.